Here's a case summary of a 2024 case where the court made interim orders to flip the primary residence of the parties' two children. So the interim orders provided for the children to live primarily with the father when they had actually been living primarily with the mother, and the mother had been their primary attachment since birth. The two children in this case, one was born in 2015, the other was born in 2013. Now, the case I'm going to summarize is actually a review. So the court made the orders to flip the primary residence, and then the mother filed a review application. So she wanted a judge to reconsider the judicial registrar's interim orders flipping the residence of the children. One of the primary reasons the court and the experts in this case formed a view that it was in the children's best interest to live primarily with the father was in response to the mother's behaviour. So the evidence indicated that the mother was unable and unwilling to facilitate a relationship between the children and the father. So let's take a look from the beginning. This is the case of Benson and Jeffries 2024. You can view the entire judgment for free using Ostley. So there are two subject children, one born in 2013, the other born in 2015. The father had repartnered and he lived with his partner, who's referred to as Ms. B throughout the judgment. They also lived with Ms. B's daughter. So as I indicated at the beginning, there were interim orders made by a senior judicial registrar following an interim defended hearing, and those interim orders flipped the primary residence of the two children from mum to dad. They were made on the 19th of August 2024. The mother filed a review application, so she effectively sought to discharge, or in substance, she sought a reversal of those interim orders. The independent children's lawyer and the father effectively seek that those existing orders be maintained. There were already final orders in place, and the court says at paragraph 9, as I understand it, there is no dispute that the 2019 orders have irrevocably broken down. I'm comfortably satisfied and find that this is a matter in which there has been a significant change in circumstance, such that section 65D(AAA) are comfortably established, and that it is in the children's best interests to reconsider the existing final orders. By way of background, the children hadn't been spending time with the father pursuant to the final orders. He filed a contravention application in March 2024. He withdrew that. He filed another one in July 2024. He also withdrew that. And then the mother filed an application in a proceeding in May of 2024, which was set down for an interim hearing in August. And she sought orders in that application. That is the application which substantially comes before this judge, having been determined and in respect of which there is a review. So as a consequence of all of that, so non-compliance with the final orders, the mother then filed the application in a proceeding. The court then made interim orders following a defended interim hearing, flipping the residence from mum to dad. Those interim orders provided for the children to live with the father and for the father to have sole responsibility for making decisions in relation to major long-term issues. The orders also restrain the mother from having any contact with the children, including through social media, mobile phone, or via a third party, except as otherwise provided for in the orders. Now, the orders also provided that if the mother didn't return the children in accordance with the orders, a recovery order was to issue, which empowered the authorising, directing, the marshal, all officers of the Australian Federal Police and all officers of the police forces of the states and territories of the Commonwealth of Australia to basically go and get the children and give them to the father. The orders allowed the mother to speak with the children by telephone, supervised by the father or his servants and agents, twice a week on days to be agreed, and failing agreement each Monday and Thursday for 15 minutes, with the calls to be initiated by the father to the mother between 5 and 6:30. And then from 30 September 2024, the children were to spend 3 hours each week on a supervised basis with the mother. There were more interim orders that you can take a look at if you go and read the entire judgment. At this point in time, you might be thinking, why did the court think it was in these children's best interest to flip their primary residence to live with dad in circumstances where these children were born and raised with the mother as a primary carer, the mother was their primary attachment? So why did the court form a view? What was the evidence that convinced the court that it was in these children's best interest to live primarily with dad and not mum? The mother said in her affidavit that the father is a perpetrator of family violence, that she has attempted to comply with the spend time orders, and the children on multiple occasions have refused and become distressed and visibly emotional when they are asked to see the father. She says that the spend time, equal time arrangement was complied with. So back when they made the orders, there was an equal time arrangement and they weren't complied with. And the mum says it got to a point where they simply couldn't be complied with, and that there were serious allegations made by the mother in her affidavit in relation to FV. The father denies the allegations of FV, and the court says, I can make no findings about that. The father says that the mother is a difficult person who seeks conflict. The court says this at 38. The father suggests in his most recent affidavit that although there has been a difficult transition, the children are now comfortable in his care. This is interesting. There were multiple expert reports that were considered and that impacted the outcome. There was a child impact report that was prepared on the 8th of March 2024 by Ms. G. So she's a court child expert. She recorded each party's history and allegations, their versions of events, their then proposals, the issues about the mother's time in South Australia, the recovery application, the litigation that followed, the disputed allegations of family made by the mother, and the disputed allegations that the mother is antagonistic and seeks conflict, which is what the father says. This expert supported the children remaining in the mother's primary care. The following is stated from her report. The children's narrative presented as aligned when discussing their experiences of both parties. The children presented that they perceive Ms. Benson, the mother, and her partner, Mr. H, as safe and trusted adults in their lives. They discussed viewing Ms. Benson as kind and caring, who is tactile, affectionate, engages with them in different activities, and is attentive to their expressed needs. The children's narrative indicated feeling Mr. Jeffries, the father, as exhibiting a harsher parenting approach that has included being smacked, whereby this has resulted in the children sustaining a bruise. The children discussed that Mr. Jeffries may yell a lot, may cause them to feel embarrassed or to miss out on treats or activities as a form of punishment, should they not wish to do what is asked of them. The court says, I note, of course, that a child impact report is a relatively curtailed process. So child impact reports are often prepared before an interim hearing. They're much shorter and concise, and the process is much swifter than a more extensive family report process. So prior to a final hearing, often family reports are prepared, and the expert, when preparing those reports, will meet with each parent, observe the children's interactions with each parent, review the subpoena material, review all filed material. So the family report that's prepared is generally more detailed than the short child impact report. So there was another expert report that was prepared by Ms. C. Ms. C prepared a single expert report. So she interviewed the parties but not the children because the mother failed to manage and obtain their attendance at the interviews. The mother relies on the children not attending Ms. C as a factor which significantly reduces the weight to be attached to Ms. C's single expert report, which was a lot more detailed and extensive than the child impact report. The other view supported by the ICL and the father is that this shows the mother is either unable to obtain compliance by the children with simple requirements where there should be no real reason for them to be afraid, or else that she is seeking to stop them being independently interviewed. The court says at 44, I cannot make findings about those matters either. Now remember, there were previous proceedings, and the court says that there was an attempt to tender the reports of Dr. J, who was a psychologist from the prior proceedings, and 3 reports of Ms. K, who was a child court expert and then appeared to have gone external. That was prepared, her reports were prepared during that litigation. The court didn't accept them since this was an interim hearing, but there was no objection to the court accepting Ms. C's record at paragraph 6 to 7 of her summary of findings. So the expert in this case had reviewed those reports and included some of the findings from those reports in her report, and that formed part of the evidence. It's pretty significant. You have Ms. K, who's prepared 3 reports previously. Ms. K prepared 3 family reports, 20 March 2017, 11 July 2017, which was an update, and then another one on the 11th of July 2019. In her final report, she concluded that, and I quote, unless the parenting arrangements change, litigation will continue, and the children will ultimately be alienated from the father to their significant detriment. She recommended Mr. Jeffries have sole parental responsibility, that their children reside with him and spend time with their mother each alternate weekend from Thursday until Tuesday. So in the previous litigation, you have an expert who met with the parties and who prepared 3 reports who were saying alienating conduct by mum, the children should live with the father. So basically, the father could facilitate the children to have a relationship with both parents, whereas the mother can't. The court references Ms. C's report and says the following: the presentation of the parties and children, the family dynamics, and the parenting strengths and vulnerabilities are unchanged. So comparing the issues in these proceedings compared to when the parties were in court before, they're saying, the expert's saying, the issues, the dynamics and the conflict, it's the same. The expert says both professionals highlight concern about the mother's restrictive gatekeeping behaviours, and both predicted the current issue. So the expert in this case is saying, back then, the experts were saying, mum's got some issues here. She's, high conflict. She's gatekeeping. There's alienating behaviors. The children should live with the father. Otherwise, there is a high chance that the litigation and the high conflict is going to continue and that the children might not be able to enjoy a relationship with their father. And this expert saying, and that's what happened. So the parties agreed to equal time when the expert in those proceedings was saying the children should live with dad. And then all this time later, the conflict has continued and the mother says, the children are distressed, they don't want to go and spend time with their father. And basically the concern the expert had in those proceedings has become a reality. The expert says, the 2 children have been subject to continued parental conflict, which has varied in intensity over the course of their lives. Of late, it has escalated, and now, unsurprisingly, X and Y, the children, are engaging in resist and refuse behaviours around a relationship with the father. The writer formed a view that an intervention is required to interrupt this chronic cycle of conflict with a view to affording the girls access to a stable, nurturing environment that will promote their development and well-being. On the current information available, Mr. Jeffries, the father, parenting style and environment is better placed to meet those requirements. The expert also said this: the mother's conduct with professionals requires commentary. School records suggest she has considerable influence over their approach to educating and supporting the children. The continuous narrative of the mother, as she says the father is a perpetrator and a groomer, looms large in the records. When the school departs from the mother's script, the reclamation is swift. She holds others to a level of accountability that she doesn't observe herself. She's highly manipulative with information and she's intimating. She generates a sense of threat by recording professionals and documenting encounters, the latter of which are controlled to reflect her litigation goals. She is not capable of hearing information of difference. Her core beliefs about the father are fixed and rigid. She cannot share the children with the father, and it is doubtful she can share the children with the school unless they adopt her narrative. Underneath the mother's assertive exterior is a devoted and anxious parent, worried that the children will love their father more than they love her. The children were not made available for this assessment. It could be argued that if the children's views and experiences have not been captured by objective reporting, the assessment is complete or compromised. The writer would assert that obtaining a free narrative, the goal of forensic interviewing, from the children is highly improbable. It is predicted that any expression would be unduly influenced by their mother's script about the father. This view is strengthened by the knowledge that the children have not spent any significant time with the father. A narrative informed by a recent lived experience of both parents would not be available to a report writer, and the absence of this builds on to concern about imbalance and distortion in any expression by the girls. Due to the chronicity of the conflict, the children's triangulation into the parental dispute, and the transmission of the mother's anxiety onto the children, the writer would signal caution about weight placed on the children's views. The short-term impact on the children will likely result in elevated stress, a spike in child-wise separation anxiety, and a grief response. There may be heightened distress with accompanying behaviours such as acting out and resistance to the father's affection and care. So if they were to flip the residence, these are the consequences. They may try to return to their mother's care. This will be more likely if the mother sabotages arrangements. Emotionally and psychologically, there may be some sleep disturbance and difficulty concentrating at school. In the medium term, there will likely be an improvement in the girl's attendance at school. There was an attendance at school issue in the case too. A reduction in Y's separation anxiety and a resumption of the normative relationship with the father as described in Ms. K's report. How the children's relationship with their mother fares in the medium term is difficult to predict. The father has been consistently assessed in family reports as a competent parent. He is psychologically stable and intelligent and has organised his work and other important relationships around his parenting role. The relationship between Mr. Jeffries and his partner was assessed as trusting and secure. Mr. B was assessed as a competent, experienced parent. She impressed as warm, responsive and accommodating. The mother has dimensions to her parenting that are functional and attuned to the children's needs. However, these strengths do not extend to facilitating a relationship between the girls and their father. She is anxious and lacks insight into the impact of this on her parenting role and responsibilities. In that context, Ms. C, the expert, recommended the children live with the father, that he have sole parental responsibility, and that there be supervised telephone communication and then professionally supervised time with the mother, as well as a range of other issues. The mother said the children's views should be given weight given their ages, and the court gave weight to the fact that the ICL had a Zoom conference with the children. The ICL was satisfied that the children appeared settled into their father's primary care. Child Y told the ICL she was missing the mother as expected, and indeed the ICL said that Y was at pains to say she missed her mother, although X was a bit more matter of fact. As I said at the beginning, the court considered all of the evidence and made orders for the interim orders to continue where the children lived with the father. They had some supervised telephone contact with the mother, and they were going to spend some professionally supervised time with the mother. At the end of the judgment, the court makes some concluding remarks. Some of those include this. Where there are untested allegations of family violence of the kind the mother makes, the court needs to be extremely cautious. However, I give some weight, obviously, to the denial by the father and to an experienced expert's concerns about the narrative. I note what I've said about the children's views, and given that one of the issues is the mother undermining the father's relationship, and given the children's ages, I give limited weight to their views, although I do acknowledge them. As always, the content of this video contains legal information, a single case summary of a publicly available case. The party named within the judgment are pseudonyms. That's not the actual family's names. Follow me for more case summaries and law talk.